All right, well, I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
Yeah, there it is. She finds, yeah, she did a finding that Mr. Sledge violated his probation. Now she's searching for recommendations from the state as to what will
Full
happen.
candor to the court, Your Honor. I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case. And I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right, well, I know that at least, I believe in the petition for revocation, the request is that the entire 30 years be revoked. Is that right?
It's not the
Or
request.
is, oh, you're just telling me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years. So he would have 26 and change or 25 and change.
I'm sorry, correct, 22.
My bad.
The exact number. That would be 27 years, 7 months, and 8 days.
All right. All right, thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Your Honor, if it'll please the court, I understand the court's ruling that there's a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation. And I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. He's turned that corner. And literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first, as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgements, and sentencing acknowledgements, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the many why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So.
In all honesty, just being revoked 5 years with his horrible lawyer is kind of a win. He could have faced all of it. But being just revoked 5 out of the 30 years, yeah. During these circumstances, I can't say that, well, during all of these circumstances, yes, it's not fair. It is not fair because we know the evilness of this prosecution. We know how they lie and cheat all the time. But Judge Whittaker here, in my opinion, her hands are tied. There is case law backing her. She could have gone for the full 30 years. And she didn't. She only revoked 5 of them. Probably the best outcome, considering he didn't fire his lawyer, he didn't throw his lawyer under the bus. It could have been so much worse. So much worse. But it's still really, really bad that Mr. Wright, his attorney, failed him this hard. I do believe revoking 5 of his probation is the time he needs to spend in prison, and then 25, and the additional 25 years will be probation after he served his time. I might be wrong, but I don't think so. But yes, he is going to prison. Sylvia Edwards. Meanwhile, Fanny skipped out of her subpoena. Yeah. Fanny Willis, who lies in church, who lies in court records, in my opinion, who is actively hindering justice in her disqualification case. She gets away with it because she has this prosecutorial misconduct immunity. During the circumstances are horrible for Mr. Sledge, and the underlying issue is the RICO, the Georgia RICO Act, which allows the state to recharge Mr. Sledge for crimes that is already been through the system. It is inherently unfair. And that is on the lawmakers. But with all of this, 5 years, I think that is the best Judge Whittaker could do for Mr. Sledge.
That's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And he will
Reinstating
be
the
continued on
balance.
probation, Your Honor?
And reinstate the balance.
Your
Thank
Honor,
you.
Might I ask, is it possible for my client to turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So
Yeah.
no, I'm sorry.
Yeah.
All right,
He
court is
is
adjourned.
going straight to prison.
Good seeing you, Judge Whitaker.
Yes, thank you. Good to see you.
All right.